Adventurous kids, explore with education and learning what a wild life is in the Everglades. I want to explore the Museum of Discovering Science. What plants do butterflies like? I want to know about Key West. Adventurous kids, learning and fun. Adventurous kids!
Today we're going to tell you about Miranda Rights. You probably heard the police on TV say something like, you have the right to remain silent. Anything you say or do may be used against you in the court of law when they arrest someone. This statement is called Miranda warning. Police are required to tell people this before they question them. As part of the Fifth Amendment, it reminds the citizen that they do not have to testify against themselves if a suspect indicates in any manner at any time prior to or during questioning that he or she wishes to remain silent, the interrogation must cease. If the individual states that he or she wants an attorney, the interrogation also must cease until an attorney is present at that time. The suspect must have an opportunity to confer with the attorney and have him or her present during any subsequent questioning. The police are also supposed to make sure that the suspect understands their rights. That means they've been legally Mirandized or informed of their Miranda rights. When you have waived your Miranda rights, you are essentially giving up your right to remain silent and your right to have an attorney present during your questioning.
There are 935 different versions of the Miranda warning. Just English. Some try to make the warning easier for people with learning disabilities, intellectual disabilities, or mental illnesses to understand. However, studies have shown that people in these groups often have even more trouble understanding the simpler version. The Miranda warning also had to be translated to many different languages. Many police departments carry cards that show the warning in different languages. Others use translators to give warning.
The ruling in the U.S. Supreme Court case Miranda versus Arizona specified the code of conduct for police interrogations of criminal suspects held in custody. The case was decided on June 13, 1966. Chief Justice Earl Warren, fighting for the majority of the justices, ruled that the prosecution may not have used the statements made by a person under questioning in a police custody unless certain procedural safeguards were followed. Courts established new guidelines to ensure that the individual is accorded his privilege under the Fifth Amendment not to be compelled to self-incrimination or show that he was involved in a crime. These guidelines detail a statement of rights known as the Miranda warnings to be read to arrested persons prior to questioning. Suspects must be told that they have the right to remain silent and that anything they say can and will be used against them as evidence. They must further be informed that they must have an attorney present, that if they are unable to afford an attorney, one will be appointed to them.
Miranda, Arizona, Sir Ernesto Arturo Miranda was arrested at his home and taken into custody to a police station when he was identified by the complaining witness. After having been identified in a police lineup, Miranda was questioned by police for 2 hours. He confessed to crimes and then signed a written statement. At trial, the oral and written confessions were presented to the jury. Miranda was found guilty of his crimes and was sentenced to 20 to 30 years imprisonment on each count. He had not been told, however, that he had the right to have a lawyer present to advise him, or that he had the right to remain silent. Miranda's confession was later used to obtain his conviction at his trial in an Arizona court. The Supreme Court ruled 5-4 to overturn Miranda's conviction. It held that the prosecution could not use the statements the police obtained from him while in custody unless the police had complied with several procedural safeguards to secure the Fifth Amendment privilege against incriminating himself. The court ruled that Miranda's confession was inadmissible as evidence, and the case was sent back to lower courts for retrial. However, Miranda was found guilty anyway, and he ended up spending 11 years in prison.
Miranda's ruling was one of the most controversial decisions of the Warren Court, which has become increasingly concerned about the methods used by local police to obtain confessions. Critics of the Miranda decision argued that the court, in seeking to protect the rights of individuals, has seriously weakened law enforcement. Later decisions by the Supreme Court limited some of the potential hopes of the Miranda safeguards.
In 2000, the Supreme Court decided the United States case concerning the Miranda warning. The Supreme Court then, under Justice William Rehnquist, was more conservative than it had been in 1966. The Dickers case gave the court an opportunity to overrule Miranda v. Arizona. With only 2 dissenters, however, the court declined to overrule the Miranda decision. Writing for the Supreme Court, Rehnquist said of the Miranda decision that it has become embedded in routine police practice to the point where the warnings have become part of our national culture.
Suspects must have a lawyer if they want one, and if the suspect cannot afford a lawyer, the state will pay for one for a suspect. That came from another Supreme Court case, Gideon versus Wainwright, in 1963. That decision, Justice Hugo Black wrote that it's impossible to have a fair trial without a defense lawyer, so that the state has to make sure that everyone gets a lawyer even if they can't afford one. If the suspect hasn't properly been Mirandized, then any evidence that comes from questioning can be thrown out of court. And also, Miranda doesn't apply to everything you say to a police officer. If the suspect is not in custody, it's a formal questioning, and the police don't have to Mirandize you, and they can still use anything you say as evidence in a case against you.
Thanks for watching
It's Adventurous Kids episode.
Blessed be.
What did you learn today?
Adventurous Kids.
Adventurous Kids.
What was the most interesting fact?
Adventurous Kids.
Adventurous Kids.
Adventurous